The federal government just moved against gun owners in a way that most people never saw coming. This isn't a rumor. This isn't a theory. This is a real policy shift that has already been put into motion and the clock is already running. If you own a firearm in this country, what I'm about to tell you could be the difference between keeping your guns and losing them forever. Best case, you walk away from this video fully prepared and legally protected. Worst case, you do nothing. And one day, someone knocks on your door and you don't know your rights. This didn't come from one single court case. It came from a combination of executive agency actions, pending legislation, and legal frameworks being quietly built right now. Legal scholars are calling it one of the most aggressive pushes against private gun ownership in American history. That's not a small statement. This reaches every gun owner in every state right now. We're talking about tens of millions of people who could be directly affected by what's already in motion. Every owner, every state, every caliber and configuration. And here's the thing, this barely made the news. The people who are supposed to be watching this for you went quiet. Most gun owners have absolutely no idea what's already been set into motion. But you're here, and that means you're about to find out. You clicked on this video for a reason. Prove to yourself you're serious about this. Subscribe before we go any further. Because what's coming next in this video is not something you want to miss halfway through. Let's start with what's actually happening and why legal experts are alarmed right now. Over the past several months, a coordinated push has been building inside federal agencies and in Congress to create new legal tools for removing firearms from private citizens. This is not one bill. This is not one agency. It's a layered strategy. And understanding the layers is how you protect yourself. The first layer is the ATF, which stands for the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The ATF has been issuing new rules and redefining terms that have been settled for decades. The agency has reclassified certain pistols as short-barreled rifles. It changed the definition of what makes something a frame or receiver, which is the part of a gun that is legally considered the firearm itself. These redefinitions matter enormously because a reclassification can turn a legal owner into a felon overnight without any new law being passed by Congress. That's not politics. That's just the legal reality of how regulatory agencies work. The second layer is red flag laws at both the state and federal level. A red flag law, also called an extreme risk protection order, allows a court to order your guns taken before you are convicted of any crime and sometimes before you even know a case has been filed against you. As of right now, more than 20 states have red flag laws on the books. Federal legislation to create a national red flag framework has been introduced multiple times, and some version of it has received bipartisan support in the Senate. The infrastructure is being built quietly and consistently. The third layer is what's happening with gun dealer licensing. The ATF has been revoking federal firearms licenses at a dramatically higher rate than in previous years. When dealers lose their licenses, the transfer system that most legal purchases depend on gets disrupted. And disrupting that system is a slow but effective way of limiting access without passing a law that anyone can easily see and fight. Now, before I get into what this actually means for your daily life, I want to know what you think. Do you believe the current legal system is still strong enough to stop a large-scale confiscation push? Or do you think the machinery is already too far along? Drop your answer in the comments right now. And while you're down there, hit the like button. It tells me to keep making videos like this one. Here's what most people are missing when they look at this situation. They're looking at each piece separately. They see a news story about the ATF. Then they see a separate story about red flag laws. Then they see something about dealer license revocations. And because each story looks like its own isolated thing, people treat it that way. But when you lay all three pieces next to each other, you see a single strategy with multiple pressure points working at the same time. That's not a coincidence. That's a plan. Think about it like this. Imagine someone wants to drain a swimming pool, but they can't just pull the plug because you're watching the plug. So instead, they turn down the water supply. Then they make a small hole in the side. Then they start arguing about whether the pool is too dangerous to keep full. Each move looks minor on its own, but put them together and the pool gets empty. That is exactly what is happening to private gun ownership under this approach. What if you legally own an AR-style pistol right now? Under the new ATF brace rule, depending on your specific configuration, it may now be classified as a short-barreled rifle. Short-barreled rifles require registration under the National Firearms Act, which is a federal law. Failing to register means you could be in possession of an unregistered NFA item. That's a federal felony. You didn't do anything different. You didn't modify your weapon. The rule changed under you, and now your legal firearm may put you at federal risk. That's not hypothetical. That's a real legal situation tens of thousands of gun owners woke up in. What if a family member, an exartner, or even a neighbor files a red flag petition against you in a state with a red flag law? In many of those states, a judge can issue an emergency order based only on that person's statement. You don't get to be in the room. You don't get to speak first. Your guns can be seized the same day. Then you have a hearing, but you're already starting from behind. Your property is gone while you fight to get it back. Even if you win, the legal fees are real, the stress is real, and the temporary loss of your Second Amendment rights is real. Here's the bigger picture, and this is the part that should wake you up completely. The legal tools being built right now are designed to survive future administrations. Regulations written into the Federal Register take years to undo. Court precedents set during this period will be cited for decades. Red flag infrastructure built at the state level doesn't disappear when a governor changes. This isn't about one election cycle. This is about a legal architecture being cemented right now that will outlast any single political moment. What I'm about to get into next is the part most channels skip completely. They cover the headline and move on. What's coming in the next few minutes is about the actual legal ripple. The case is in the courts right now. The challenge is already filed, and what could either stop this or accelerate it? You want to be subscribed before I get there. So, turn on the bell right now and make sure you don't miss the follow-up videos as this continues to develop. Let's talk about what's happening in the courts because this fight is very much alive. After the Supreme Court handed down its decision in New York State Rifle and Pistol Association versus Bruin in 2022, the legal landscape for Second Amendment challenges changed significantly. The Bruin decision written by Justice Clarence Thomas established a new test for evaluating gun laws. It said that any firearm regulation has to be consistent with the historical tradition of firearm regulation in the United States at the time the Second Amendment was ratified. That is a powerful standard that has already been used to strike down several lower court decisions. Courts across the country are now applying the Bruin standard to challenge red flag laws, bump stock bans, restrictions on carry permits, and the ATF's new rules. Some of those challenges are succeeding. The Fifth Circuit Court of Appeals, which covers Texas, Louisiana, and Mississippi, has already struck down several ATF regulations. The Eighth Circuit and the 11th Circuit have issued conflicting rulings on related questions. That conflict between circuits is exactly how cases end up at the Supreme Court, and several cases are now positioned to do exactly that in the next 1 to 2 years. The Supreme Court also decided Garland versus Cargill in 2024, ruling 6-3 that the ATF had overstepped its authority in banning bump stocks through regulation rather than legislation. 6 justices voted to protect that boundary. 3 said no, the side that once sent a clear message. The ATF cannot rewrite federal statutes by calling something a different name. That ruling is now being used as a template by attorneys challenging other ATF reclassifications, including the pistol brace rule. This is just the beginning of the court battles that will define gun rights for the next generation. Watch what happens next in the federal circuits because the Supreme Court is watching too. Every split decision between circuits is another invitation for the nation's highest court to step in and set the national rule once and for all. Now, let's bring this into your actual life because understanding the law is only useful if you know what to do with it. Here are 3 realistic situations you might actually face and what the law means for each one right now. The first situation, you own a pistol with a stabilizing brace and you've done nothing to modify it. You bought it legally. You registered nothing because nothing required registration when you bought it. Under the ATF's current rule, depending on your configuration and how you use it, it may be classified as a short-barreled rifle. The safest legal move based on current guidance is to speak with a licensed firearms attorney in your state and get clarity on your specific setup. Do not assume you're fine without checking. Do not assume you're in violation without checking either. Get real legal guidance because the answer genuinely depends on the details of your specific firearm. The second situation, you live in a state with a red flag law. You've had no legal trouble, no mental health history, Nothing that would normally trigger concern, but you have a difficult relationship with a family member or a neighbor who knows you own guns. Under most red flag statutes, that person can go to a courthouse and file a petition claiming they believe you're a danger. They don't need evidence beyond their statement. In many jurisdictions, the best protection you have right now is documentation. Keep records of any disputes. If relationships are volatile, consult a family law or firearms attorney before anything escalates. Know the exact statute in your state and what the burden of proof is at the initial hearing. Knowledge is your first line of defense here, not hardware. The third situation, you want to buy a new firearm and you go to your local dealer. The dealer is operating normally, but you've heard about license revocations. If your dealer loses their federal firearms license after you've transferred a gun, but before the paperwork clears, that creates a legal gray area that takes time to sort out. The simple protective step is to use dealers with established long-term records and to complete transfers completely and quickly once you start them. Don't leave transactions open-ended or dragging across weeks. Now, let's clear up some of the noise you're going to hear because bad information is everywhere right now, and it can hurt you more than ignorance can. The first myth is that this is all just talk and nothing is actually changing. People will tell you that confiscation has been threatened before and it never happened. That's technically true in the mass door-to-door sense. But confiscation doesn't have to be dramatic to be real. Regulatory reclassification that turns legal owners into felons is a form of constructive confiscation. Red flag seizures are legal confiscation under court order. License revocations that dry up the legal transfer market are functional confiscation through access denial. It doesn't look like the movie version, but the effect on your rights is just as real. Don't let the absence of a dramatic moment make you think nothing is happening. Something is happening right now. The second myth is that the Supreme Court has already solved this and you're protected. People point to Bruin and Heller and McDonald and say the Supreme Court has settled it. Those cases are absolutely important and they've created real legal protection. But a Supreme Court ruling is only as effective as the lower courts applying it correctly, the agencies following it faithfully, and the attorneys willing to litigate when they don't. The ATF issued the pistol brace rule after Bruin. States kept their red flag laws after Bruin. The ruling created a better battlefield, but the war is still being fought on that battlefield right now. Don't think a past win means you're permanently protected going forward. The third myth is that if you're a law-abiding citizen, none of this applies to you. This one is the most dangerous myth of all. The entire mechanism of regulatory reclassification is designed to turn previously law-abiding citizens into offenders without requiring them to do anything new. The law changes, your behavior doesn't. And suddenly the gap between those two things is a federal charge. Law-abiding status is not a permanent shield. It's a description of your relationship to current law. When current law changes under you without warning, your status changes with it whether you knew about it or not. That is exactly why watching this stuff matters. Not because you're a criminal, but because staying law-abiding in a shifting legal landscape requires staying informed. Here is where we are and what you need to carry out of this video. The first thing is this. The push against private gun ownership is not a single event. It is a layered strategy using regulatory agencies, state-level legislation, and litigation to reshape what is legally possible for gun owners over time. Each layer works with the others, and the combined effect is greater than any single piece looks on its own. That's by design. The second thing is this. The courts are fighting back. Bruin gave attorneys a real tool. The Cargill ruling gave them another one. Cases are moving through the circuits right now that could either lock in protections or open new vulnerabilities depending on how they're decided. The next 2 years in federal appellate courts are going to matter enormously for every single gun owner in this country. Pay attention to those courts, not just the political noise around them. The third thing is this. Your personal protection starts with your personal no-FULH. Knowing your state's red flag statute, knowing the legal status of your specific firearms under current ATF rules, and knowing which actions require legal counsel before you take them. That is the practical defense that actually keeps you safe. No one is going to hand you that information. You have to find it, understand it, and use it. This is bigger than any one case or any one agency rule. What's being built right now in carouses and federal registers and state legislators will be the legal world your children and grandchildren inherit as gun owners. The Second Amendment has survived 2.5 centuries because people in every generation took it seriously enough to defend it, not just in words, but in knowledge and in courts and in the choices they made every single day. You just spent real time getting smarter about your rights. Don't let that stop here. Nobody's going to hand you this information on a mainstream platform. You have to be in the right places to get it. This channel is one of those places. Subscribe. Hit the bell so you never miss a ruling or a rule change. Drop a comment telling me which part of this video hit you hardest and share this with every gun owner you know who needs to hear it. The people who stay informed are the ones who stay free.